Good morning. This is your Kelso Report for Tuesday, June 12th. I'm your host, Clark Kelso. We have two Supreme Court decisions to begin with today. The first involving the judicial review of civil service decisions. In Elgin v. Department of the Treasury, the Supreme Court resolved the question of whether the Civil Service Reform Act of 1978 provides the exclusive procedure for obtaining judicial review when a federal employee challenges an adverse employment action by arguing that a federal statute is unconstitutional. The problem arose in a case where the defendant was terminated because he had knowingly and willfully failed to register for the Military Selective Service, which pursuant to a statute made him unqualified for his position. He wanted to challenge the statute on constitutional grounds. When the administrative law judge who was assigned to the case under the Civil Service Reform Act held that he had no power to declare a statute unconstitutional, the employee said, "I'm going to dismiss the appeal, file an original action in the district court." Well, the Supreme Court, in order to retain a unitary review system, held that Congress intended to establish in the Civil Service Reform Act the exclusive procedure for reviewing adverse employment actions, and that was review through administrative appeals up to the federal circuit. With respect to constitutional claims, the ALJ is supposed to permit the claim to be made, along with letting the applicant make any applicable record, so the Court of Appeals for the Federal Circuit, which ultimately reviews adverse actions under the Act, has a basis for resolving the constitutional claim. The Court's holding preserves the basically administrative law character of the Civil Service Reform Act. Next, we have a habeas corpus case from the Supreme Court. This time, the Supreme Court slapped down the Sixth Circuit in Parker v. Matthews for using the writ of habeas corpus to set aside two 29-year-old murder convictions based on what the court said was the flimsiest of rationales. The Supreme Court described the Sixth Circuit's decision as a textbook example of what the Anti-Terrorism and Effective Death Penalty Act of 1996 proscribes: second-guessing reasonable decisions of state courts. The main issue at the trial and on habeas was whether there was sufficient evidence that the defendant had committed a murder under extreme emotional disturbance, which, if true, would reduce the crime from murder to first-degree manslaughter. Now, as you can imagine, this is primarily a fact question, primarily for the jury, and they ultimately found against the defendant. The Sixth Circuit undertook a detailed analysis of the state Supreme Court's decision and decided that their conclusion, the state court's conclusion, was legally doubtful even under state law. But as the U.S. Supreme Court noted, the case was submitted to the jury on proper instructions. There was plenty of evidence both ways, and the jury found against the defendant. The Sixth Circuit's conclusion that there was insufficient evidence in light of insufficient evidence of extreme emotional disturbance was rejected by the Supreme Court, citing plenty of conflicting evidence. The case is a good reminder from the Supreme Court, and apparently the lower federal courts need lots of reminders, that federal habeas is not the place to relitigate close cases on the facts. The court also granted review in two cases. First, the securities law class action. They granted review in Amgen versus Connecticut retirement plans to consider a couple of important questions in a class action alleging securities fraud. The Ninth Circuit in this case held that it was not necessary to prove materiality as a precondition to invoking a fraud on the market presumption of reliance at the class certification stage, and that the district court correctly refused to consider a truth on the market defense at the class certification stage. The court will review these conclusions when it hears the case next term, and in light of the Supreme Court's recent decisions on class actions, where they seem to be moving review of the merits further and further up into the class certification decision, I think we can expect a reversal here. The court also granted review in a double jeopardy case in Evans versus Michigan. The Supreme Court's going to take a look at what the Supreme Court of Michigan did in the case. The Supreme Court of Michigan held that a directed verdict, order of acquittal, and dismissal of a criminal case was not an acquittal on the merits for double jeopardy purposes. The state court reasoned that the trial court had made a serious mistake of law by adding an unnecessary requirement for the charged crime. And since the dismissal therefore had nothing to do with the defendant's guilt or innocence under the proper elements of the crime, the double jeopardy clause did not apply. I'm guessing the Supreme Court is going to reverse this one. Certainly jeopardy had attached by the time of the trial court's dismissal. And if we start trying to distinguish between types of legal errors committed by the trial court during a trial, we're going to be going down a very slippery slope for double jeopardy purposes. Next, we turn to the Ninth Circuit for a search and seizure case. In United States v. Grant, the defendant was convicted of being a felon in possession of firearms. That was based on a search of his house that was conducted ostensibly to discover evidence about a murder that occurred 9 months earlier, not at the house, somewhere else. Although the application for the search warrant was voluminous, basically saying everything the police knew about the crime, nothing in the application established anything more than a speculative connection between that homicide and the defendant's house. The Ninth Circuit also held that the good faith exception did not apply, since a reasonable officer would know that a probable cause did not exist when the facts alleged in the application do not plausibly connect the place searched to the item they're searching for. The evidence should have been suppressed. Next, a bad faith insurance case in the Ninth Circuit. In Doe v. Allstate, the Ninth Circuit faced a garden variety bad faith refusal to settle. The insurance company had engaged in settlement talks that were initiated by the plaintiff fairly early in the underlying litigation, which arose out of an automobile accident. But no settlement was reached, and a jury imposed damages above $4 million, well in excess of policy limits, as well as in excess of settlement talks. In the bad faith action, the trial court refused to give a jury instruction that an insurer has an affirmative duty to effectuate settlement once liability has become reasonably clear, even in the absence of a settlement demand. In other words, the insurance company has a go-first duty. The Ninth Circuit held that even if such an affirmative duty does exist under California law, and the Ninth Circuit thinks it does, the facts in the case did not justify giving that instruction, since the insurance company had in fact been engaged in early settlement talks, and there was no evidence at all to suggest that the result of those talks would have been different if the insurance company had initiated them. Accordingly, the trial court's failure to give that instruction was harmless, and the Ninth Circuit affirmed the pro-insurance company verdict. Next, we have an in rem forfeiture case in United States v. Farrow. The owner of a $2.5 million gun collection had transferred ownership of that collection to his wife shortly before being prosecuted and convicted in state court of unlawful possession of explosives. That conviction made it impossible for the husband to keep his license to possess the guns. Over 15 years later, federal authorities seized the gun collection based on his continued possession of firearms without a license. The in rem forfeiture was challenged by his wife, the owner, on grounds that she was entitled to the innocent owner defense and that the seizure violated the Eighth Amendment. Well, first, the Ninth Circuit rejected the innocent owner defense, holding that the defense is not available to someone who knew all of the relevant facts giving rise to the property's forfeitability and simply did not understand the law. As for the Eighth Amendment claim, the court held that under the Civil Asset Forfeiture Reform Act of 2000, a civil forfeiture of the instrumentalities of a crime, here the guns, can still be reviewed for excessiveness. And excessiveness review should focus on the individualized culpability of the property owner. The trial court had not focused on the wife's culpability, so the Ninth Circuit remanded for reconsideration of that issue. Thus, even though the wife may not get the benefit of the innocent owner defense, she may ultimately retain some of the gun collection if her culpability was sufficiently low that forfeiting the entire collection is excessive. And that's it for today's Kelso Report. Have a great day in the law.